This is Faith Under Fire. We take you straight to the voices on the front lines of religious battlegrounds. I'm news anchor Sarah Harnisch, and with me today, Attorney Thomas Breth. We're talking religious rights of kids. A huge religious freedom case won in Pennsylvania, the City of State College up against a group of families of children attending religious schools. Here's the question. Can those kids go to public school extracurricular activities? And the answer is yes.
We asked the federal judge to rule in the parents' favor based upon a First Amendment free exercise violation of the U.S. Constitution as well as an equal protection violation. And I'm happy to report after almost 2 years of litigation, the parties resolved the litigation this year, and a consent order was entered by the judge enabling all of the students that attend parochial schools within the State College Area School District to have the same rights to participate as homeschool and charter school kids.
Parochial schools are directly affiliated with a religious organization like a church. How is this a win for religious freedom in the Keystone State?
In many ways, it seems to be a subtle win, but it's such an important win. So many of these parents that want to send their kids to parochial schools to further their religious beliefs have to make the choice between, do I continue to grow my religious faith with my children, the family, or do I send them to a public school where they have greater opportunities for athletic scholarships? Many of these public schools, like the State College Area School District, have a vast array of educational offerings. AP courses, honors courses, a larger array of language courses and things of that nature that unfortunately smaller parochial schools just don't have the resources to offer. So obviously their children say, listen, I want to play lacrosse, and the parochial school doesn't have a lacrosse program. I want to dance in the musical, or I want to pursue French or a different language that isn't offered in the parochial school. And they've had to forbear those opportunities to foster their religious beliefs. And that's a decision that's a discriminatory scenario that they shouldn't be put in.
Yeah, and these are parents that are paying taxes to the schools. So they're paying for their kids to go to these religious parochial schools, but then they're also paying taxes to the schools that their kids that are in that age group can't attend.
Many of them said, I don't understand why you're objecting. We're paying taxes the same as any other resident in the school district pays taxes. In addition, we're paying to have our children educated at a parochial school, which relieves you of the financial obligation to educate our child. All we're asking for is a small component of the opportunities that you provide to your students, that you offer that small component of those opportunities to our children.
Now, this is an interesting case because you guys settled. So it wasn't a verdict from a judge, but the school district in Scranton said, all right, we'll do it. You settled out of court, correct?
Correct. We settled through the mediation process in the Middle District. So the Middle District of Pennsylvania, which is a U.S. district court, and with the assistance of the court's mediator, not only did we settle, but it's really important because we received an order of court signed by the judge. So it wasn't a mediation where the parties just tell the court, we settled it and closed the case. We actually negotiated a consent order that both parties presented to the court and said, Judge, we consent to you entering this order. Unlike a lot of settlements, we have an order of court, which is a decision from the court. The court reviewed the consent order, the judge agreed with the terms of the consent order and entered it as an order of court. So it's not a jury verdict or a bench trial verdict, but it's the same result. We have an order of court saying that the students that attend parochial schools in the State College Area School District have the same rights as charter school and homeschool kids to participate.
Will this have a ripple effect for other districts across the state?
It's already started. I've spoken with 3 or 4 other parents of students that attend parochial schools across the state, both in the eastern end of the state as well as other parents in the western and middle part of Pennsylvania that are in very similar circumstances. So I believe it will have a ripple effect. We are looking to clarify this statewide so that all of the school districts within the state, including the Pennsylvania Interscholastic Athletic Association that governs athletics in the Commonwealth of Pennsylvania, that everybody recognizes that these students have an individual constitutional right to participate in the same manner as homeschool and charter school students. And once that occurs, I think it'll be just a fantastic victory for those people of faith and just opportunities for the kids, because I think when these kids have more contact and share their faith and have the ability to say, yeah, I go to a parochial school, I love it at a parochial school, I'm able to get a great education, I'm able to further my faith and my family's faith, but I also have the opportunity to participate in these activities with you. I think it sets a great example for all the students that they interact with.
This isn't over. It actually just got a lot bigger because of the PIAA, the Pennsylvania Interscholastic Athletic Association. Can you explain what happens next?
Correct. We've been in contact with the PIAA. As part of the state college settlement, we acknowledge that the state college area school districts' athletic programs are primarily governed by the Pennsylvania Interscholastic Athletic Association. And as such, they have some authority over the state college school district. So the consent order has a carve-out for that. We've been in contact with legal counsel for the PIAA and have said, listen, your constitution and bylaws have a carve-out for homeschool and charter school students, and quite honestly some other students in different circumstances, in the same manner as the state college school district's policies had carve-outs for homeschool and charter school students. The PIAA is a state actor for constitutional law purposes. They are the state for that purpose, the same way as the state college school district is. There's no separation of the type of entity. So they have the same constitutional obligations as the state college area school district. So we've put them on notice that we expect them to amend or interpret their bylaws in a manner that permits parochial school students to participate in their home school districts, their district of residence, their athletic programs, and that the PIAA will recognize that they're eligible to participate in those programs, just as the PIAA recognizes homeschool and charter school students are eligible. And if they don't, we're prepared to continue the litigation. We've been litigating against the PIAA and file a federal lawsuit very similar to the lawsuit we filed against State College, because it's just a form of discrimination that has to stop. It's been going on for too long, and it needs to stop across the Commonwealth of Pennsylvania and country for that matter.
You defend faith-based groups across the state. Why does this case and religious freedom matter so much?
I think people have kind of become numb to the issue. I think it's been such a common practice of discrimination that I think most people don't even recognize it as discrimination. And as I talk to various people about the case and the legal theories behind the case, many times it takes them a while to realize, you know what, now I understand. That really is wrong. That really is discrimination. You can't make exceptions for homeschool students and charter school students and then say, but no, parochial school kids, they're in a religious school. You get this separation of church and state. So to me, it's a process of educating people on, you can't just say separation of church and state and somehow that, makes you immune from accountability for denying generally available benefits to individuals solely based upon their religious beliefs. And that's what's been going on, and it's been going on for a long time. And with the help of my clients and with the good Lord guiding us, hopefully we'll be able to bring it to an end.
Learn more at thomasmoresociety.org.